Hello, and thank you for joining me on this for this webinar. My name is Raphael Tachie. I am a partner at Dowling WLG, where I lead our private client group in Vancouver. And my practice is mainly focused on high net worth estate planning and tax planning, but also in most instances providing advice to investment advisors, financial institutions, insurance advisors on the issues that come up around estates that impact their practices. So in particular, for this topic, you find that maybe it impacts you personally, or your clients personally, but it might also impact your practice or your business as an advisor or financial institution. So happy to respond to questions and stuff like that can flow out of the presentation. So love and predatory marriage, it's really for this presentation really explores the circumstances under which somebody might marry somebody just purely marry another person where that person is either elderly or senior or it's vulnerable in some way. And the purpose of the marriage is to gain access to that person's finances. How do you deal with these things? How do you know when there's a problem around those things? So as an outline, first we'll describe what a predatory marriage is. And then to get an understanding of how the law view these things, you need to understand the capacity to marry. And really the law starts off by saying there's a presumption that we are all, if you're an adult, you are capable of marrying and the different standards that apply. We'll then talk about marriage contracts and the capacity to marry, and then highlight some of the instances where courts have set aside a marriage because it was predatory. And if you're dealing with somebody that's involved in these places, what are the red flags you should see or look out for when you're dealing with a marriage where you think is predatory? We'll look at some case law around these issues, and then we'll finally talk about what are some practical steps you can take when you find yourself in this kind of space. So what is a predatory marriage? It's a type of elder abuse or senior abuse where a person, as I described earlier, enters into a relationship with somebody that's otherwise vulnerable in some way. I know I have elderly on the screen, but really think of elderly really relating to vulnerability, either in mental capacity to understand what's happening or in an exploitation of somebody that's dependent on the person that's entering into the marriage. And the purpose of that marriage is exclusively for the purpose of gaining access to the vulnerable person's finances or estate, right? So you have to have two things. Not only do you have to be married, but then you have to have some element of vulnerability in a person that's involved in a marriage. But then the purpose of the marriage has to relate to gaining access to the vulnerable person's finances or estates. Before we talk about this, it's key to understand a couple of issues, public policy positions that are embedded in BC law around predatory marriage and marriage generally. So under Section 55 of the Wills, Estates and Succession Act, I'll use that term WESA for short, for those that don't know that. There's a public policy reasons why we don't, if Raphael has a will today, and then I enter into a marriage, my will is not revoked by the fact that I entered into a marriage after I signed it. That's because BC has taken the public policy position that we do not want to negatively impact beneficiaries of a will just because I got married. The spouse who might not be named in my old will have recourse in the courts to access some of the estate that I leave behind. And so generally from a public policy position, we do not consider a marriage to revoke a will. Now let's talk about what is required, what is capacity, and what is required to have the capacity to marry somebody else. One, that under the law, capacity is a legal test. And the law presumes that every adult has capacity to do certain things. Now, capacity, as we know, can fluctuate over time, right? So I might have a good day today if I'm elderly, where I remember everything, I'm fully capable of making decisions, and I might have a bad day where I'm not able to remember and understand everything I'm doing. It can be progressive. It can be that I'm good today, but over time, my capacity degrades. And so I lose capacity along the way. For lawyers, when we're assessing capacity, as I said, it's a legal test. We might rely on medical evidence to support our analysis, but ultimately the decision about somebody's capacity, legal capacity to do something, is always a legal test. It doesn't matter what the doctors say. It can be helpful in landing on the legal capacity, but it's not a requirement that you rely on the medical evidence. And it's not a medical decision. You can have different levels of capacity for different things, and I'll explore that in more details in the coming slides. That's really important to keep in mind, that the capacity to do one thing, to enter into a marriage, is different than the capacity to divorce or separate, from the capacity to grant a power of attorney, let's say, the capacity to make a will. All those things have different levels of capacity. So when you're dealing with a situation, you need to understand what is involved, the task that's being done, and what is the level of capacity you need to be able to do those things. Now, the burden of proving that there's no capacity, especially in relation to a marriage, is determined on the balance of probabilities. So the way I describe a balance of probabilities is, what are the chances that this person lacks capacity? So is it a 50% chance, or is it more than a 50% chance? That's really the standard, right? So when courts are assessing capacity, or lawyers are assessing capacity, it's a balance of probabilities. And it's not a really high standard to say, okay, you have to know everything. Courts are going to look at what are the chances that this person didn't have it, and you'll look at the evidence surrounding the task of the activity that we're discussing. So let's look at a few cases that explore the different levels of capacity. The first case I'll highlight for you is Wolfman and Stotland. So Wolfman Stotland case in 2011, and that case is by the BC Court of Appeals. In that case, in trying to resolve the issue at hand, the court looks at different levels of capacity required to do certain things. It says if you're for separation, it's the simplest act. It requires the lowest level of understanding, right? So to separate from somebody, it's not a very high threshold to say that I know that I'm separating, I'm walking away from this relationship. That's a very low level. But that level of capacity is different from the capacity you need to divorce. While it's still simple to divorce, it requires a bit more understanding of what divorce means, because you might get a divorce order, you might enter into other arrangements that divorce causes. So that's why separation's lowest level, divorce might be a little higher. Now, how about the contract of marriage? How do you enter? What is the level of capacity to enter into the contract of marriage? It's still, courts are saying it's still simple. I don't know if I agree with that, but it might be a little bit higher than you need for separation, for example, right? Now, the last two things that we're going to talk about, the last two bullets, require higher levels of capacity to be able to do those things. The distinction between understanding what's a personal matter versus a financial matter, right? So where personal matter, I think of where am I going to live, with whom am I going to live, those kinds of decisions. Financial matter obviously is hopefully clear by its terms. The level of capacity and understanding that you need for dealing with a financial matter, it's high. And we'll talk about that as we go through this exercise and we go through these slides. But this is a rough hierarchy that the BC Court of Appeal in the Wolfman Stotland case sets out around the levels of capacity you need to do different tasks. I've narrowed this discussion to around marriage and things like that, but clearly you could have other things where you need capacity. Now, the second case I want to highlight is a case where the court considers the capacity to marry, and in particular, the capacity to enter into a marriage contract. I'd like to highlight for you, for example, that the court says, as a phrase, that it is a simple contract, which does not require high intelligence to comprehend. Interesting. I'm married, and I would say, I don't think my marriage is a simple contract, because we had to work out who does what, who does the dishes, who takes our daughter to daycare, who does all those things, who manages the money, how do you manage it? There's a lot of complexity in marriage that this definition doesn't really address, but that's what we have, right? So it's a simple contract, does not require high level of intelligence, which would be consistent with some of the hierarchy that we saw in Scotland, right, where the court went through the different levels of capacity. It does not involve consideration of a large variety of circumstances in other acts involving others, such as making a will. So here, the court introduces the idea that the level of capacity, which is called to make a will, which is called testamentary capacity, is higher than what you need to enter into a marriage agreement. So if you go back to the previous slide, you could almost add testamentary capacity, maybe a little bit after financial and legal matters, right? So that's kind of what the court is doing in the other case. Now, let's look at the public policy case, and so you notice that this case is a little bit older, it's 1952, and it's coming actually from the Manitoba Court of Appeal. And here, the capacity to marry is the court identified as a public policy reasons why they set that capacity. The interest of the public in upholding marriage is recognized in law by the rule that everything, including capacity of parties, is presumed in favor of marriages. So here, what the court is saying is, we're going to, if you're an adult entering into a marriage, we're going to presume that you have the capacity to enter into a marriage. So the standard to marry, very low. The capacity to marry, very low, because the courts are going to presume in favor of marriages, and that's essentially part of public policy that wants to recognize marriages. So the next piece is, let's look at check out the Feinstein case from the 1930s, and this is really on here because it takes a line from Durham and Durham, which is an old case from England, where it is stated that the capacity to enter into a valid contract of marriage is a capacity to understand the nature of the contract and the duties and responsibilities which it creates. So here, the definition is a little bit, it fleshes it out a little bit more, but it really doesn't tell you what the duties are and the nature of the contract. Like, you know, it says that's, you need to understand the nature of the contract, but it doesn't actually say what is the nature of a marriage contract, doesn't define those things. But you start to see in these line of cases that valid capacity is capacity to understand the nature of the contract you're entering into and the duties and responsibilities which is created. But further cases tell you those things you're going to need, they are very low barriers to jump over, as we've discussed before. It appears to me this is a case, this is Durham and Durham. And so the 1885 case where the other case pulled out of, it appears to me that a contract of marriage is a very simple one, which does not require a high degree of intelligence to comprehend. Now, as I said, my marriage requires a high level of intelligence. I suspect that if you're married, you probably feel the same way. Well, but in 1885, even though the court sets out initially that, you know, you need to understand the nature of the marriage contract, you need to understand the duties that are involved. In Durham, which is being relied on, it says you don't need a high intelligence to comprehend those things. So what's the current test? What is the test that's being applied currently in BC? That you can find in Ross Scott v. Potvin in the 2014 case. And in that case, the court discusses that a person is capable of entering into a marriage contract only if that person has the capacity to understand the nature of the contract, the duties and responsibilities, basically the Durham cases, right? Then it says the assessment of a person's capacity to understand the nature of a marriage commitment is informed in part by an ability to manage themselves. So you have to be able to manage yourself and your affairs. So now it's a little bit complex, but still not complex, because remember, the line of cases later on says the standard to do all of those things is still low. So, but it clarifies a point, right? It says delusional thinking or reduced cognitive abilities alone may not destroy an individual's capacity to form an intention to marry. That means I can marry for the wrong reasons. I can marry because I think somebody loves me and they might not love me, right? Delusional thinking does not go to capacity, as long as the person is capable of managing their own affairs. So as long as I can manage my own affairs, I can marry for the wrong reasons and it's still valid. So we know marriage now, the standard to get married is very low. The capacity to get married is low. You have to understand the duties involved, but and the nature of the contract, but you don't need high intelligence to understand all of that. And as long as you have the capacity to manage your other affairs, you can marry. So let's look at some cases where the court have set aside marriages, and what if you're dealing with a situation where you think there might be a predatory marriage, what are the things you should be looking for as red flags? One, if there's a clear lack of capacity to marry, then the marriage is void at the beginning, from the beginning, right? So it doesn't matter. But it's difficult to set aside those marriages. And you see some of the case law that I'll walk you through, that it's really difficult to set aside marriages because the standard to marry is low. And once you're in it, you need a lot of evidence to say that this is not the right thing. The other piece, so where do you start? You start by looking at medical records. Yes, the capacity to marry is a legal test, but you need, if you can have evidence that is a problem, then you can form this set of facts in which, on the balance of probability, that it's likely that the person may have lacked legal capacity to marry. So do you have medical records that say the person had some kind of condition that impacted the ability to understand and enter into a marriage contract? What is the circumstances of the marriage? Were there gifts? I'll use, again, you see in some of the case law that sometimes the gifts are exploited, right? There's other grounds for invalidating a marriage. Usually it's because the marriage is unconscionable, or there's fraud in it, or there's an undue influence, and we'll come to undue influence. Undue influence is a relationship between the people in the marriage such that one is vulnerable in some way and depends on the other person. So the other person has an undue influence over that person's decision such that they actually take away their own capacity. And we'll explore that in some of the cases that come up. In BC, this is new, I just learned this myself. If you suspect there's a marriage is predatory, you can file a caveat under the Marriage Act that says this person is vulnerable in some way and cannot enter into a marriage. So that might sometimes be a solution where the marriage hasn't taken place, but you know it's going to take place. So let's look at some of the case law. This 2017 BC Deborah Thompson, a BC Superior Court case. In that case, the deceased met Poulain in late 2006. And then the niece involved in the care and regular took care of the deceased at the time. Took her to a geriatric medicine specialist. In February 2007, the deceased appoints the niece who took her to the doctor, and a friend has her powers of attorney. Family noticed changes in behavior of the deceased at the time, hygiene, untidy, apartment is not clean, those kinds of things. So signs of kind of personal neglect. 2 years later in July of 2009, the deceased makes a will. June 4th, 2010, a year later, there's a secret wedding. But there's also a certificate of incapability issued in September 2019 that says this person is not capable. Then he died in 2014. So in that case, the niece brings an action against Poulain to invalidate the marriage and the 2009 will that was made after the marriage. And then brings in an expert that says probably insidious onset of cognitive impairment existed, with overall picture consistent with dementia, probably of Alzheimer's type. So there's medical evidence that this is kind of where the deceased was at the time the deceased married and made a new will. Evidence from family and friends lined up with the expert evidence. So you have family and friends telling the story, the medical evidence backing it up. And Poulain's evidence was in stark contrast with everything that the family was saying and the doctors were saying. And that in this instance, the court didn't believe that he was credible. So starting point for a test of capacity is marriage is a contract. So you have to have the low threshold to understand the terms of the marriage contract. Some understanding of with whom a person wants to live, some understanding that it will have an effect on the person's future, in that it will be an exclusively mutually supportive relationship until death or divorce. And then in that case, the court says that the deceased did not have capacity at the time to marry, so the marriage was void at its beginning, and that impacted the will. So there's a second analysis around capacity to make the 2009 will that was also void. So let's look at another case, Hunt. There's an Ontario case. And in Hunt and Warroad, an action is brought by what's called litigation guardian in Ontario, which is if you're vulnerable somewhere and you don't have the mental capacity to bring a legal suit, somebody can step in your shoes as your litigation guardian and bring a suit on your behalf, which is what happened in this case. So 50-year-old Hunt had catastrophic brain injury. So here it's not really a decline, it's an accident, right? And spent 18 days in coma. Disappeared after being released from the hospital, and then found 3 days later after he married somebody. So coma, 18 days of coma, gets up, wakes up, disappears. 3 days later, he's found and he's married. Evidence, substantial expert evidence that Hunt's brain injury and loss of executive functioning, which is there's a capacity issue around his ability to understand what he's doing. Substantial lay witness evidence of effect of the brain injury in relationship with Warroad. So again, in this instance, we're looking at the circumstances around the event where courts look at it and then say on the balance of probability, is it likely that this person didn't have capacity to marry? So here, the main issue is that Hunt have capacity to marry. If the answer is he did not have capacity, then the marriage is void from its beginning. Alternatively, if Hunt's marriage is void on the basis of equitable doctrine of unconscionability or unjust enrichment. So there's two issues. So one is, okay, if you didn't have capacity, marriage is done. Even if you had capacity, but because of the brain injury, then was the marriage unconscionable or unjust because this person's really marrying for a financial windfall? Test for capacity. They went to the Roscott case that we discussed earlier. Persons entering into a marriage contract must understand their duties and responsibilities which a marriage creates and have the ability to manage themselves and their affairs. And here, the person that's saying you don't have marriage, which is in this case, the plaintiff's sons, have the burden of proving that you lack capacity, right? So you're presumed to have capacity unless somebody that's claiming you don't have capacity proves it on a balance of probability. Here, the evidence was in favor of voiding the marriage. And in this instance, the court did. So now that we've kind of seen the line of cases where the courts have actually gone ahead and overturned the cases, you have to realize that there was significant medical evidence that there was a problem. There was a lot of corroborating evidence from people around those individuals that supported the medical evidence. So you need a really high standard of evidence to be able to impact someone's marriage, to declare that somebody didn't have the capacity to marry. Now, the case study, let's look at a case study where, as an advisor, how are you going to be involved in these things and what are the tools available to you if you're ever involved in something like this? In this case, M is married to D. M has an adult child from a previous marriage. M is in her 70s and has lost capacity due to dementia and is in assisted living. And so clearly lacks capacity. D is in his 70s as well. And C, who is the daughter of M, is a busy executive at a financial institution. So D and C, even though they're stepchild to step parent, have a good relationship. A few months after M's incapacity, D enters into a relationship with another person. So here, there's some estate documents in place that before all of this happened, right? So prior to losing capacity, M implemented an enduring power of attorney on the basis that D is the attorney. If D cannot act, C is the attorney to act in his place, and the attorney can use M's assets for the benefit of D. This is standard planning for most families, right? Most spouses. You appoint your spouse as your attorney. If something happens to you, your spouse steps in. If your spouse needs anything, needs something, and you have excess, it can be used for your spouse. Standard planning. The financial circumstances for these clients were that they had approximately $2 million in an investment account that they both held jointly, again, before mom lost capacity. $2 million held in private banking account in the names of M and D. There's a principal residence valued at $3 million, again in joint names. Any joint account can be signed, or anyone can sign or make withdrawals from joint investment and banking accounts. The concern here is over the last year, D has depleted all the funds in the private banking account, and is increasingly making withdrawals from the investment account. D has moved the new person in his life into the home that he shared with M. Right? And then the stepchild suspects that the funds are going to P because D is depleting those funds way too quickly. He purchased a Porsche for P, he rented and purchased equipment for a hair salon, has taken numerous vacations where D paid all the expenses, and D and P expect that they're going to want to live together and they want some kind of relationship for permanence. They haven't said marriage yet, but it looks like that's where they're headed. What's a concern? C reports their concerns to the financial institution where all these accounts are held, right? So imagine you be an investment advisor and a stepchild walks in and says, this is what I'm seeing, there's a problem here. The financial institution's view was that D and M lived extravagant lives, so expenditures did not appear unusual. That's fair enough, right? When M was fine, they took fancy vacations, they did fancy things, they spent a lot. So not unusual on its face. Maybe that's why as an advisor of such an institution, they didn't catch it. D does not appear to lack capacity when interviewed by the financial institution as unwilling to submit to a capacity assessment, right? Because I'm fine, I know what I'm doing, I met somebody new, life is short, I want to spend my money. That can be a legitimate answer. Now, D's view is that C is unwilling to confront D directly, where in a lot of advisors, this is where you get caught in the middle because the children want a good relationship with a step parent. They do not want to have to cause a problem, but there is a problem because the funds are going and mom, who's in assisted living, might need those funds for her own needs. So what is the analysis here? Look at M's needs. They cannot manage finances because they're incapable, they're in assisted living, cannot remove her attorney, which is D, because again, not mentally capable of doing that. So the capacity to do those things are much, much higher than marriage, can't do anything about it, can't fix it. So M cannot fix the problem. So then the second is, look, what is the obligation on an attorney where the adult is incapable? So what's the obligation that D has to M because M is incapable and D is managing their money? Can use assets for the benefit of the attorney per terms of the power of attorney. So here D can spend M's money. The power of attorney lets him do that. It's clear that that's what they intended. As I said, that's very normal planning for spouses. It's not a problem unless D is being exploited and now he's depleting assets in a way that impacts both him and his former spouse that's incapable. The attorney is not meeting obligations since assets are being depleted at a rate for another person's benefit, right? So, financial institution looks at its agreements and it permits restricting attorneys' access to accounts if the attorney is acting improperly. Here, because the attorney is depleting assets at a very fast rate that is going to impact M, there's an opportunity to step in. If the attorney is not acting improperly, then there's a basis to refer the attorney to public guardian and trustee, which is really what happens here. So now what is D's need? So we've looked at what M needs. We looked at the attorney's obligations, and now we're looking at D, because D also is a joint account holder. So you have to look at D's needs. It's not willing to submit to a capacity assessment, right? You have to presume that capacity unless you have a reasonable basis to think otherwise. So you can't really force D to do a lot other than just in his capacity as an attorney. So is D a victim of undue influence? Potentially, but you don't know that because D is saying, no, I'm just choosing to spend my money the way I see fit. No one's influencing my choices. As an advisor, you're not the skilled, it's not on you to determine to full legal satisfaction that undue influence exists. So what are your choices? Here, what happened was the financial institution permits D to spend funds in joint accounts for his sole benefit since D is a joint account holder and with anyone to sign on the joint accounts. But if the financial institution places a temporary hold because there's likely financial harm to M, right? And so what you have to do is you look at each person's options, go, what is the likelihood of exploitation here? So one of the solutions that financial institution comes up with is, can I get D to go get independent legal advice on what he's doing and his obligations as an attorney to M? Offers it, doesn't take it. If I offer supportive decision-making with C to say, hey, D, can you come in with C so we can explain to you what we're seeing, why we're concerned, rejects it. So for you as an advisor, what you're really, all these steps are going to, is you're documenting what steps am I taking to help resolve this issue, right? To help bring as many people to the table to help resolve this issue if possible. So here, the solution and the advice I gave to the financial institution involved was, place a temporary hold on the accounts and the expenditures, refer D to the public guardian trustee because D is still an attorney for M and M's interests are not being protected. Right? D might have all the rights to deplete all his money personally, but what about M? Right, so let's place a temporary hold and then make a referral to the PGT. By communicating that to D in this agreement, in this instance, he comes to the table and says, okay, fine. If you're so concerned about M, then what I'll do is I'll split our assets into two, right? So that we know we're sure and guarantee that there's funds available for M and that I can go ahead and live the life I want to live because I know that I'm fine and I want to deplete my assets and I want to be with P if I want to. D then agrees to resign as attorney for M so that C can step into it as an attorney. And in this instance, the solution is the stepchild gets a portion of the assets to look after for mom's benefit. And because we don't have the ability to independently satisfy ourselves that D lacks capacity, we have to presume he has capacity. You can make stupid choices with your money. You can make stupid choices with who you want to live with and how you want to live with that person. In that instance, that D continues to do that. And that is the solution we end up with. Not a perfect solution, but as an advisor in this instance, what you've done is satisfied yourself that if there's a problem, you've looked at it, you've tried to bring the public guardian trustee into play, you've tried to bring the stepchild into play, you look to segregate and protect M's interest in the money that they built together, and you've respected these the capacity, the presumption of capacity to spend this money the way he sees fit. What is the win here? The win here is you address the concerns in the best way that as an advisor of financial institutions you can. You can't solve everything, but what you've done is, as the investments for M stays with the financial institution because you protected them. You protected M. Investment advisor and private banker learns more about private trust offering, in which case they actually came up with a better solution where they offered a trust offering for C that allows her not to have to be involved every day because she's a busy executive, and C stops complaining to the business about why her mom being exploited. Here, we didn't solve the predatory issue, but what we did, how it presented itself, was in the case where the advisor in the financial institution are placed in the middle of a family dispute, not really a dispute, concern, and you aren't, as an advisor or financial institution, you're not in the position of solving predatory marriages. You just have to recognize when they show up and then try to take steps to protect the people that might be impacted by it to the extent possible. You're not going to have a foolproof solution. This is not a foolproof solution, but it works well because it protects the most vulnerable person in this scenario. So that is the end of this presentation. I'm very glad that you've joined, and hopefully you found it useful. Here's my contact if you have any questions, or if you have any issues that you want to reach out to me, please feel free to do so. It's very I appreciate the opportunity to speak to you and present to you. Thank you.